If you are a green card holder who travels outside the United States, whether for a vacation, to visit family back home, or for work, please pause and watch this entire video. In 2026, there are 3 significant rule changes that have reshaped the situation for lawful permanent residents at U.S. ports of entry. And I am not referring to minor technical details hidden in fine print. I mean changes that are already leading green card holders to be sent into secondary inspection, questioned for extended periods, pressured to surrender their status, and in some situations denied entry to the country they have been living in for years. I have spent a long time working in U.S. immigration, and I want to be upfront with you. Right now, the margin for error is smaller than it has ever been. So whether you are planning to travel next month or next year, this video could be the key step that helps you protect your green card. Let us get into it. First, let me provide some background, because understanding why these changes are happening will help you understand why they deserve your attention. The United States Customs and Border Protection Agency, commonly known as CBP, has long had broad authority to inspect anyone who is not a U.S. citizen when they arrive at an American port of entry. This includes airports, seaports, and land crossings. And this authority also applies to lawful permanent residents, including green card holders like you. What has been changing in 2025 and continuing into 2026 is both the technology CBP is deploying and how enforcement priorities are being applied. In recent years, there has been a tightening of enforcement posture from the Department of Homeland Security, including expanded vetting protocols, new digital tools, and a clearer direction to examine returning permanent residents with greater care than was routine even 2 or 3 years ago. The 3 rules I'm going to cover are not guesses. They are based on actions and policies tied to CBP, DHS, and U.S.CIS, and they are affecting real travelers. So let us go through them one by one. The first rule, and honestly the one that surprises many people, is what I will call the biometric capture rule. Effective December 26, 2025, the Department of Homeland Security put into effect a final rule that permits CBP to collect facial biometric data from non-U.S. citizens upon entry to and departure from the United States. You should pay close attention to the meaning of every in this context, because it reflects a major expansion of the approach. Previously, biometric collection at ports of entry applied mainly to visa holders and certain categories of travelers, with exemptions for diplomats, many visitors from Canada, and children under the age of 14. Those exemptions have been eliminated. As a green card holder, you are a non-citizen, which means you fall within the scope of this rule each and every time you enter or leave the United States. At airports, CBP may photograph you and compare that image against government databases quickly using facial recognition technology. The same general process can apply at seaports. The rule also extends to land border crossings and to CBP pre-clearance facilities abroad, such as those in Dublin and Toronto. So if you are thinking that a smaller crossing will make the process easier to avoid, that is not a safe assumption as implementation continues in phases. Now, here's why this matters beyond obvious privacy concerns. This system can be used not only to confirm identity, but to compare whether your live biometric information matches government records tied to you. If there are any mismatches between your travel documents, your biometric information, and CBP's databases, that can lead to referral to secondary inspection. What kinds of mismatches are we talking about? Instances where your current travel document does not align with information connected to your green card, or where your travel history in the system raises questions about prior departures and re-entries that were not accurately recorded. And once you are in secondary inspection, officers may have broad authority to question you about your life in the United States. Immigration law firms have noted a rise in clients being directed to secondary, including people with clean records and fully legitimate travel histories who were simply caught in the updated verification process. The practical step you need to take right now is to ensure your travel documents are consistent and up to date before you travel. Your green card, your foreign passport, and any records connected to your immigration status should be aligned. And if you have had any status changes recently, such as a green card renewal, a name change, or an address update with U.S.CIS, Make sure those updates are reflected in the official records before you depart. Do not assume that because nothing was flagged before, nothing will be flagged now. The system is new and it is actively comparing data that used to be stored in separate systems. The second rule has the longest history behind it, but in 2026 it is being applied differently in practice, and that is the continuous residence and abandonment presumption rule. Most green card holders have heard some version of the 6-month rule, meaning that being outside the United States for more than 6 months can cause issues. But I want to explain exactly what each time window can trigger because there is a lot of confusion, and that confusion is leading people into serious problems. Under CBP regulations, grounded in federal immigration law, specifically in Title 8 of the United States Code, a trip of fewer than 6 continuous months is generally treated as a temporary absence. In those cases, CBP officers may be less likely to challenge that you intend to maintain permanent residence during that window, though they can still ask questions at any time. A trip of 6 months to 1 full year is treated differently. Once your absence reaches that 6-month threshold, you may be viewed as someone seeking readmission to the United States rather than only returning from a short trip. That means the legal presumption changes. CBP may shift from treating you as simply returning as a resident to evaluating whether you still qualify for readmission. And if you exceed 1 full year of continuous absence abroad without a reentry permit, your green card is generally treated as invalid for reentry purposes. Airlines may decline boarding, and CBP may begin removal-related actions after arrival. What has changed sharply in 2026 is not the underlying legal concept itself. What has changed is how aggressively that standard is being applied. CBP officers are now operating under expanded vetting expectations that can lead to heightened scrutiny for returning green card holders, especially those who have been abroad for extended periods. But the part that matters most and where many people are caught off guard is that officers may look beyond only the length of the most recent trip. They may consider the overall pattern of your travel. If you have made multiple trips over the past 2 years, each one slightly under 6 months, but your combined time outside the United States significantly outweighs your time inside it, that can raise concerns about where your true permanent residence is. Because under immigration law, permanent residency is not only paperwork, it is tied to the reality of where you live your daily life. The question CBP officers are trained to ask is straightforward. Does this person genuinely live in the United States? Factors may include your employment situation, whether you have been filing U.S. taxes, whether you have a home here, whether your family is here, what your financial accounts show, and what your reasons were for being abroad during that time. The steps you need to take are practical. Before you travel internationally, assemble a document file and bring it with you. That file should include proof of your U.S. address, such as a lease agreement, a mortgage statement, or a utility bill. It should also include your most recent U.S. federal tax returns, because filing taxes as a resident is one of the strongest indicators that you regard the United States as home. It should contain pay stubs or an employment letter if you work here, along with any other documentation that shows your life is anchored in the United States. And if you know you will be abroad for more than a year for any reason, whether it is family circumstances, a medical situation, or a work assignment, you should file Form I-131, the application for a re-entry permit, before you leave. This permit, issued through USCIS, can allow a green card holder to remain outside the United States for up to 2 years without automatically triggering the presumption of abandonment. But this point is critical. You must submit the application while you are still physically present in the United States, and processing times may be substantial under current USCIS workloads. Do not wait until the week before you depart. Plan this months in advance. There is one more detail about this rule that you need to understand clearly. If you arrive at a port of entry and a CBP officer concludes that you have abandoned your permanent residence, they may present you with a document called Form I-47, which is the record of abandonment of lawful permanent resident status. This form, if you sign it, can mean you are voluntarily giving up your green card. I want to be clear, you are not required to sign that form. Signing is your choice. No matter what pressure an officer applies and no matter How long the encounter lasts? Only an immigration judge in a formal hearing has the legal authority to decide whether you abandoned your status. If you decline to sign, CBP must issue a notice to appear for immigration court, which allows you to present your case to a judge with appropriate legal representation. If you ever find yourself in that situation, the most important step is to contact an immigration attorney right away. Do not sign anything without legal counsel. The third rule is the broadest in terms of how it affects privacy and how you should prepare. And I am referring to the expanded digital and secondary inspection vetting rule. In 2025 and continuing into 2026, the U.S. government has expanded its use of social media screening, device examination, and cross-agency data sharing as part of the immigration vetting process. Let me explain what that can look like for a returning green card holder. When you arrive at a U.S. port of entry, a CBP officer may conduct what is called a basic search of your electronic devices. In practice, that can mean they may be able to review information on your phone, such as messages, photos, emails, and applications, as part of the inspection process, without needing a warrant and without requiring a specific suspicion of wrongdoing for that initial review. They may also review your social media accounts. While they generally cannot access content stored in the cloud without an advanced search, which typically requires reasonable suspicion and supervisor authorization, the basic search alone can still provide them with a significant view into your personal life. The fact that such searches can occur is grounded in the border search exception to the Fourth Amendment, but the number of these searches has increased under current enforcement conditions. What is particularly new is how device data and social media information can be fed into a broader vetting infrastructure. USCIS announced in December 2025 the creation of a new USCIS vetting center based in Atlanta, designed to centralize enhanced screening of applicants and returning residents. This center has access to DHS databases and law enforcement intelligence resources, and it is conducting what officials describe as comprehensive reviews of individuals' immigration histories, including matters that were previously approved. The center is prioritizing cases involving nationals from countries designated as countries of concern, which as of early 2026 can be a growing list that includes individuals from more than 30 countries impacted by presidential proclamations issued in June and December of 2025. If your country of birth or citizenship appears on that list, you should anticipate a higher likelihood of enhanced scrutiny at the port of entry, even if your green card is valid and your trip was short. This does not necessarily mean you will be refused entry, but it does mean you need to show up prepared. So what should you actually do to prepare? First, before you travel, take time to review your social media accounts and make sure publicly visible content cannot be misunderstood or taken out of context. This is not about hiding who you are. It is about being thoughtful and deliberate. Second, understand that you can decline to provide passwords to CBP officers conducting a basic search. Be aware, however, that refusing may lead to device confiscation and extended questioning. U.S. citizens cannot be denied entry for refusing, but for green card holders, the situation can be more complex, and the consequences of a difficult encounter can be serious. This is why saving the contact information for an immigration attorney in your phone before you travel is reasonable caution. It is responsible preparation. Third, make sure there is nothing on your devices, messaging apps, or emails that could be read as evidence that you live primarily outside the United States. If you have been communicating extensively about foreign employment, ownership of property abroad, or long-term plans to remain outside the country, a CBP officer reviewing your messages could use that information to question your intent to maintain U.S. residence. I want to pause and address something important. I understand that some of this may feel unsettling, and that is not my intention. Most green card holders who travel abroad and return to the United States will not be refused entry, but the room for error is genuinely smaller than it has been recently, and the consequences of getting it wrong can be life-changing. A green card represents years of effort and years of building your life in this country. It deserves the same care and attention you used to earn it in the first place. The good news is that the steps to protect yourself are straightforward and achievable. Carry your documents, file your taxes, keep your records consistent, apply for a re-entry permit before a lengthy trip, know your rights at the port of entry, and if things take a difficult turn, remain calm and do not sign anything until you have spoken with an attorney. A quick reminder before we wrap up today. All immigration policy is subject to change. The rules discussed in this video reflect official guidance from U.S. Customs and Border Protection, the Department of Homeland Security, and USCIS as of May 2026. I strongly encourage you to verify the most current guidance directly on the official CBP website at cbp.gov and on the USCIS website at uscis.gov, which are updated regularly. For your specific circumstances, please consult with a qualified immigration attorney. Nothing in this video constitutes legal advice, and every individual situation is different. What I can offer you is knowledge and a framework to ask the right questions and take the right steps before you travel. And we are here to make sure you have accurate, up-to-date information delivered in plain language, so you can protect yourself, your status, and your future in this country. If this video was helpful, please give it a like, because that tells us we are on the right track. Share it with anyone you know who holds a green card and travels internationally, because this information could genuinely make a difference in someone's life. And please subscribe to this channel if you have not already done so. We publish regular updates on immigration policy, enforcement changes, and practical guidance for permanent residents and new arrivals. And you do not want to miss what is coming next. Check the description below for links to official CBP and USCIS guidance pages, along with resources for finding qualified immigration legal assistance in your area. We are always in your corner.